And welcome back inside the law. I'm your host, Philip Holloway. You may have been surprised to see this live stream pop up so quickly. And by the way, for those of you who are looking really close at this, maybe if you're a regular here inside the law, you might notice something is different behind me. Yes, I'm traveling. And if you've been watching the show recently, you'll know that I am in Florida for the meetup with Eric and Mark from America's Untold Stories, and of course, our good friend Viva Fry. So we are here. We are looking for, in fact, I'm meeting up with Eric just a little bit later on, and we are going to be talking a lot about you people. And maybe we'll record it, maybe we won't. It depends on what we have to say. But nevertheless, here I am. I'm in a hotel room, quite obviously, but I'm fortunate. I've got good internet. I did Eric's show from here earlier today. He has a noon show called Laid Back Law. We talked all about lots of things, including defamation, Netflix. We talked about the Trump trial, Michael Cohen, a lot of the things that we've been talking about here recently inside the law. But this morning, I got this gem that hit my phone, and it looks like the divorce drama involving Nathan Wade, the former special prosecutor for Fani Willis in Fulton County, and his wife Jocelyn. You may remember back a few months ago when the entire Fani Willis thing really broke, and the fact of the affair and all this, we started also watching the divorce case that's pending between Mr. and Mrs. Wade in Cobb County, Georgia, which is next door to Fulton. And that was where the marital home was. You remember from the testimony in the disqualification hearing, there was testimony about cell phone data tracked Mr. Wade from his home in Cobb County down to the Love Shack condo in Hapeville, Georgia, where apparently Nathan was shacking up with Fani Willis, and that whole thing became just an entire separate thing in and of itself. But what it did, let's just say it caused a splash, and it created additional litigation in the context of the divorce case. Willis was even scheduled, she was subpoenaed and scheduled to have to give a deposition about the affair. She was able to, I guess, file motions to quash it and all this. She pushed back real hard. But then, if you remember, they reached a settlement before there came time for any hearings that would have required evidentiary hearings like testimony from Nathan Wade or even from Willis. They settled it. Well, I mean, what else is going to bring the parties to the bargaining table better than perhaps a lot of public pressure to get the thing settled? Because the last thing you want to do is have to testify more about this than you already are going to have to. All right, so they came to the bargaining table. They reached a settlement, but it wasn't a final settlement. Okay, at least in Georgia, when you have a pending divorce, a lot of things have to happen before you get a final divorce. You're still married, but you're going through the divorce process. Usually early on, at some point anyway, before the end, there's usually a temporary agreement, particularly when people have kids, and then there's issues of who may or may not need spousal support. There will be an agreement. Well, if there's not an agreement, you're going to get an order. A judge is going to force this on you. You're going to have a hearing. Somebody's going to ask for a temporary order. If you can't reach an agreement, you're going to have a hearing, and the judge is going to tell you what the temporary order is. And what the temporary order does, or a temporary agreement, if they come to an agreement, it governs the parties' conduct with respect to each other for the pendency of the litigation. In other words, until it's over. And when it's over, there's a final order that replaces the temporary or interim order. Now, that order also, it will do things like establish who pays who spousal support. And that's based on the relative circumstances of the parties. Who makes more money, who has more money, who's got other bigger needs and things like that. And children, are they minor children? Are they adults? All of those things are issues in a case that ultimately have to be decided in a divorce. But until you reach the final result, there's something that's temporary, because by definition, people who are divorcing can't get along. So you gotta have a court order that forces them to follow it. And if they don't follow it, you can ask the judge to hold them in contempt for not following an order. All right. So that's the 10,000-foot overview of sort of what's happened up to now in the Wade versus Wade divorce. All right. And by the way, there's 412 people in here at 4:00 in the afternoon Eastern time. And thank you so much for being here. I love to see it. Go ahead and hit that like button. It helps people find this channel who have maybe a curiosity in how the law works, or whatever. And also hit the subscribe. Make sure you like and subscribe, and tell all your friends and your family and your neighbors, everybody you know. Tell them to create 5 or 6 or 7 different accounts and subscribe from all of them. No, I'm just kidding about that. But I am trying to get to 30,000 subscriptions. I'm over 28, I think, now. So we're trying to get to 30. That's the next goal. If you'll help me get there, I would really appreciate it. And if you like the content, there's links in the description for how you can support Inside the Law. All right. So with all that said, I know everybody's furiously hitting the like button as we speak. Okay, so now let's take a look. This is not what was filed today. This is the defendant's application for a citation of contempt. And I want to, let's see if I can make that a little bigger. And then I've done a separate video, I think, on this, but I'm going to point out some of the highlights. It says defendant's application for a citation of contempt. If you notice here at the top, Nathan Wade's the plaintiff, Jocelyn is the defendant. So Jocelyn is telling the judge that Nathan is not following the temporary order, and that because of that, she's asking the judge to do something about it. Contempt can mean any number of things, but in an extreme example, it could mean jail. We're not there yet, though. All right, so she points out that on January 30th of this year, 2024, the court entered a consent temporary order, the one like we were just discussing. It was reviewed and approved by the court. They agreed it would not be filed with the court, but that it would nevertheless be the order of the court. And they didn't file it because they don't want us to know what's in it, which is not, look, that's okay. It's not, when you have a high profile divorce, people don't want the general public knowing all of their business necessarily. So it's not uncommon sometimes for parties to agree that the contract or the order that the judge issues is not going to be public, but it became public later. We'll get to that. All right. Here they actually start quoting from it. The temporary agreement states as follows: the plaintiff will pay uncovered medical expenses for the defendant. So Nathan has to pay Jocelyn uncovered medical, apart from any elective cosmetics, a cap of $500 a year. The defendant will forward invoices to plaintiff, who will pay them instanter. That means right away to the medical provider, or make other arrangements. Plaintiff will be notified by defendant, and plaintiff shall arrange for payment instanter. All right. So this is providing for the immediate payment of medical bills. Here you go. 3, it says defendant urgently requires medical procedures, namely an endoscopy, colonoscopy, and an ultrasound due to severe physical symptoms she has been enduring. These symptoms have significantly impacted her ability to consume foods. She's lost a lot of weight, and was in worsening health, she says. And I'm just kind of skimming here, folks. This is all out here for you to see, and take a look at. But for our purposes, I'm just going over it very briefly to sort of set the stage for the next thing. It says the defendant has notified the plaintiff of the urgent necessity for these medical procedures and the need for prepayment in the amount of $4,400 specifically, and she has communicated that the medical facility will not even schedule these vital tests that she says she really needs until there's been a prepayment. Despite a direct request, in other words, she called Nathan herself and asked him to do this. So despite a direct request and an additional demand between the lawyers, plaintiff, that's Nathan, according to her, has failed and neglected to fulfill his obligation to do that. So he's not paying the medical bills she needs. Goes on to say, on the day immediately following the entry of the temporary order, the plaintiff, Nathan, informed the daughter, who's an upperclassman in college with hopes of entering medical school in the near future, that he would discontinue payment of her rent and living expenses, instructing her to, quote, get the money from your mother. It was noteworthy that the daughter's rent was due that very day. So Nathan, if you look, reading between the lines, Nathan had been supporting his adult daughter, as parents oftentimes do. Oftentimes voluntarily, right? It's just kind of part of being a parent. Sometimes you support your kids even after they are over 18 in many instances and in many ways. But he apparently, according to this, stopped and said, get the money from your mother. It's noteworthy that the daughter's rent was due that day, demonstrating the defendant's unwavering commitment to her children. She promptly covered the daughter's rent payment and has continued to do so every month thereafter, with the money that she receives in spousal support under the temporary order. Okay. So what was going for spousal support is now being diverted to the daughter's needs. And it says the plaintiff has punitively reneged on his commitment to cover their daughter's MCAT expenses as well. The MCAT being the exam that you take, and if you make a high enough score, you get into medical school, right? That's the sort of the entrance exam for medical school. He punitively reneged on his commitment to cover her MCAT expenses. Moving on to the son, it says the son is currently in Europe pursuing a career as a professional soccer player. Now, those are those athletes. Professional soccer players are the most athletic people on the planet. Anyway, back to the law. Despite the plaintiff executing a verified affidavit to the country of Spain, affirming financial responsibility for his son's expenses for visa purposes. See, in Spain, unlike America, when they let foreigners come in, they got to make sure that the foreigners have a means of support and are not going to become dependent on the government of Spain to take care of them, to feed them and house them and clothe them and give them health care and everything else. So that's how Spain does it. He had to have a verified affidavit affirming financial responsibility for his son before they would even let him in Spain. He subsequently informed his son shortly after the temporary order was entered that he would no longer be providing support for him either, telling the son to, quote, get the money from your mother. In response, and unwilling to leave their son in a foreign country without support, the mother has been covering all of his expenses as well, including costs for the visa application, et cetera, et cetera. Plaintiff's sudden cessation of support for the party's children has placed the defendant in a dire financial situation, resulting in monthly income of less than $1,000. Additionally, defendant cannot currently work due to her health. As a consequence, she finds herself in a worse financial position than she was prior to the entry of the consent order. She acknowledges the court doesn't have jurisdiction over the expenses of the young adult children. However, she gives this information as context. Lastly, pursuant to the order, the plaintiff was to pay a total amount of $15,000 to Frazier Dieter, the firm employing the defendant's financial expert. It says plaintiff personally provided a cashier's check made payable to Frazier Dieter in the amount of $15,000. Defendant's counsel, who sent the same to Frazier Dieter by FedEx lost the package. And defendant's counsel requested plaintiff to have the plaintiff address it with the bank. So it says here, upon information and belief, what that means is a lawyer says, I've got a good faith basis for saying this. Plaintiff had one contact with the bank who wrote a letter saying that they did a, quote, deep dive and it would be 90 days before they could reissue the check. I thought you could just go cancel or stop payment on the check and get them to cut a new one. And even if you can't, if this is something that's, urgent, write another check and get the other one canceled later. But in any event, apparently there was nothing else done. It says plaintiff's multiple willful failures to comply with the terms of the temporary order constitutes contempt of court. So they go on asking for a hearing, attorney's fees, so on and so forth. All right. So this is what I offer you by way of background. All right, before we move into today's filing, let's check in on the chat. I see that you guys are doing a lot of talking in here. A lot of it I'm not able to see. I will go back, by the way, and try to watch the live chat in the replay. Unless I've got to do any editing, the live chat will be something that I can go back and view. And I do enjoy reading the chat, looking through it, and seeing what people say to each other or things that they may say to me that I miss during the live stream. So I appreciate all of your comments. If you have a question, if you'll help me out, preface it by saying question and then ask your question. And that way, when I look over and see it, I'll see we've got a question. For example, obviously, S. Carr is saying happy Friday from Cobb County, and happy Friday to you. This, of course, being the county that we're talking about is Cobb County. It's where this litigation is going on. And then we have, obviously, I see you guys, like Sherry is making a comment here to the entire group. Oh, guess what? We've got Senior Chief is back with us. Senior Chief, all right. So last night I was with Eric Hunley and his wife, and Eric's also former military. He's in the Army. And we were talking about you, and I hope your ears weren't burning too much, but we were talking about you, and we were talking about, well, we didn't think that we could handle being, in a submarine and being claustrophobic. But anyway, Senior Chief spent an entire career, became senior enlisted non-commissioned officer in the U.S. Navy in the submarine service, and he is with us again. And thank you very much for the super chat. Always appreciated. That's what helps us continue to provide additional and new content for the channel. All right. Now, let me make one change here, and I want to add a different court filing. Let's say share screen. I'll go to these windows. All right. This should be the right one. Defendant's amended response. All right. So now, let me make this a little bigger for you guys. Hopefully you can see it. The defendant's amended response to plaintiff's emergency motion to modify consent, temporary agreement, and request for emergency hearing. So after the last filing that we just went over, around that time, Nathan Wade had said, look, Fannie Willis's money, the checks have been cut off. I'm not getting the checks anymore. My circumstances have materially changed, and therefore I'm asking the court to go ahead and modify and amend the temporary agreement because I'm making less money. Okay, so he called it an emergency motion, and so now he's amending his emergency motion. Okay. I'd said that wrong. The defendant, Jocelyn Wade. See, this is, you gotta have a whiteboard. You get confused. I keep thinking he's the defendant in this case. He's not. He's the plaintiff. So she is amending her response, and this is why it's so interesting. So apparently, by the way, here we have more lawyer talk where it says comes now. I mean, I don't know why lawyers can't just say, here's what's going on, and just write like in plain English, but I do it myself. I'm guilty of it. I don't understand why we do it this way, however. All right, so the defendant is amending her response to the plaintiff's emergency motion to modify the consent temporary order. And here's what, I get into the meat of it. It says that on April 8th, plaintiff filed this emergency motion to modify the consent temporary agreement and request for emergency hearing. It's premised on the plaintiff's contentions that his resignation as a special assistant district attorney in Fulton County, was it? I mean, I guess technically it was, but when you're told that you got to leave by the judge, is that really a resignation? Anyway, His resignation in that case constitutes a substantial change in circumstances, rendering him unable to meet his financial obligations. She says, she being the attorney for Jocelyn, goes on to say, due to plaintiff's consistent failure, that's Nathan, due to Nathan's consistent failure to provide accurate or timely discovery responses in this matter, the defendant sought, listen to this, guys, updated financial documentation from Fulton County regarding plaintiff's employment as a special assistant DA. The response provided to the defendant by the Fulton County chief financial officer revealed that the plaintiff was issued 2 checks dated 3 days before he filed his, quote, emergency motion to modify his support order. And these 2 checks totaled $53,000. So we have an additional $53,000 coming from Fannie Willis to Nathan Wade. And 3 days later, he files a pleading with the court saying that his financial condition has deteriorated to the point that he wants to get out of his support obligations. That's what that means. That's what that means, guys. 53,000 more dollars. And that was been this year. That was like 2 months ago or something, right? So, and she says there appears to be no plausible explanation other than the plaintiff's deceitfulness. You know, I'm sensing a theme.
There's nothing more powerful than the odor of mendacity.
Anyway, I get distracted by that. There seems to be no plausible explanation other than deceitfulness, mendacity, to justify his pursuit of emergency relief, essentially alleging insolvency. Which, if you're insolvent, it means you're broke, completely broke. If you're insolvent, when in fact he had received $53,000 only 3 days before, as additional evidence of plaintiff's lack of candor and deceit towards this court. There's
nothing more powerful than the odor of mendacity.
Deceit. I'm sensing a theme here. Is it just me, or do you guys sense a theme? By the way, if you hear anything, if you hear me say anything and you disagree with it, you think I'm full of crap, just put it in the comments. I want to see what you think about all this. Whether you agree with me, whether you don't agree with me, engage with the chat. And if you're watching this on replay, let me see what you have to say in the comments. And I do look at them a lot. It's kind of like one of the death scrolls. I tend to look through it on my phone. I'm looking at the comments when I got spare time, and I will reply to a lot of them. And I like to see when you agree with me. I like to see when you disagree. I just want to hear what folks have to say and think about it. All right. Anyway, by the way, there's over 1,000 people in here now. Welcome. For those of you who weren't here in the beginning, we are going over the latest in the divorce drama between Jocelyn and Nathan Wade. And now Jocelyn is claiming that Nathan is lying to the court about some things. She's already asked the judge to hold him in contempt, which could possibly include throwing him in jail, but we're a long ways off from that. And so we're just going through what this latest is that's come out today. I mean, this thing has really heated up. I thought that it would have been settled by now, but apparently these folks are, particularly Jocelyn, she is digging and digging. Her lawyer, is contacting Fulton County and finding out, exactly what the situation is. How much money is he getting in all this? Additional evidence of plaintiff's lack of candor and deceit towards this court. Both checks and corresponding invoices to Fulton County pertain to work performed in October and November of 2023. Plaintiff did not resign until March 15th, 2024. Okay, so he's being paid for work from last fall, but he did not, quote unquote, resign until March. You know what she's getting at? If you know what she's getting at, and you hadn't read ahead on this document that I got on the screen, tell me in the chat where we're about to go with this, because this, what to me, is fascinating. All right. What she's getting at is there's more money coming from Fannie to Nathan. That's what this is coming to. All right. Plaintiff did not resign until March 15th, 2024. Thus, it is reasonable to infer that there are further outstanding payments due to plaintiff that likely have not been dispersed as of the current date. Attached here too are exhibits A, B, and C. A and B comprise checks from Fulton County made payable to plaintiff, accompanied by corresponding invoices detailing work performed. Exhibit C consists of plaintiff's resignation letter dated March 15th. Defendant, so in other words, she doesn't know yet, but she knows that he's been submitting invoices and he's only been paid through like October of 2023. So yeah, there's probably a boatload of more money that's coming. And so she's like, he's not being honest with the court when he says that his circumstances have materially changed to the point that he needs to be relieved of his support obligations. Well, he relieved himself of a lot of his burden when he voluntarily decided to stop supporting his adult kids. The one that's trying to get into medical school and the one pursuing a professional career in soccer over in Spain. So he lightened his burden there a lot. But Jocelyn clearly doesn't believe that he is as destitute as he is essentially claiming to be. My words, not his. He's never claimed the word destitute, but he's claimed that in these pleadings that his financial circumstances have changed to the point that he needs to be relieved of his obligation to support his wife according to the consent. It was an agreed upon order. It wasn't an order that was forced on them by the judge. It was an order the judge signed, but it was based on an agreement that they made when they came to the bargaining table when Ashley Merchant found out about the affair. That's what it was. Defendant Jocelyn has incurred additional attorney's fees to defend against plaintiff's baseless motion, which is completely devoid of any justiciable issue of law or fact and could not reasonably be believed that the court would accept the same. It lacks further substantial justification, thus entitling defendant to attorneys. So she's going after Nathan for attorney's fees for basically, as she says, filing frivolous litigation. These motions that he's filing, she says, are frivolous. She says it's frivolous on its face because he's still being paid at least up through March. And he's still got outstanding monies owed to him, according to her, from Fannie Willis. And so I want to know what I wonder. I wonder if we are ever going to know exactly how much money she paid him up through the 15th of March. When Ashley Merchant filed her motion, it was over 600 something thousand, but that was as of a certain date that was well before the fall of 2023. So he continued to work on the case. And if his billing habits are any indication, he billed a lot for several more months. I'm guessing it's going to be closer to $1 million. If I had to guess, I'd say it's, 900,000. That would be my guess. I'm going to ask somebody who might know, probably as soon as we finish here. I'm going to start seeing what other people who know about these things think, but I would say it's pushing $1 million. All right. 1,351 people. If you all hit the like button right now, that will help other people who are interested in this subject matter, who are interested in the court system and the legal system. It'll help them find this channel. The more insiders we have, the better. Also, 1,363 people who are watching this live. Hopefully, you're all subscribers, and if you're not, just go ahead and subscribe. It doesn't cost you anything, and if you want to join as a member, that's great too. Because all the support, any support, helps me to continue to provide additional content like this. What we do here, for anyone who's new, is we use things that are in the news. Or things like this that we've all been following. We use actual stuff. And this, look here today, we're looking at pleadings. We do this so that people who aren't familiar with the real world court system, legal system, justice system, it will bring you inside the law so that you can see the world that I see in my career, having been doing this for I don't know, 28 years or so. I'd have to do the math, but I want to share this world with you. So this is why we explore it. And if you subscribe, or if you know somebody else who's interested, have them subscribe, because that really helps the audience grow, helps the channel grow, and we can continue to bring additional content. Um, I can't wait to see, when I go back and watch this replay. I can't wait to see the live chat. Cindy, I agree with you, Cindy. I think I'm brilliant too. No, I'm teasing, but I appreciate that. Look, this is look, I am not brilliant. This is just this is really kind of ordinary stuff for me. It's not ordinary for you. So that's why I just try to share with you the way that I see things, which is not always right. Other people have other ways of looking at things, and you may disagree with me too. And I want you to tell me if you disagree. That the comments that are supportive are obviously nice to see, but the comments where people, hopefully you're going to disagree in a nice, polite way, but I want to hear what you have to say if you see it another way. So I do appreciate the comments and the thoughts. All right, guess what I'm doing tonight? Okay, Eric Hunley and I, y'all know Eric. All right, we're gonna when Eric is going live in about an hour with Mark. They're doing their America's Untold Stories. And so as soon as I get through watching America's Untold Stories, I'm going to get with our friend Eric Hunley, and we're going to go see what kind of trouble we can get into down here in Florida. So if any of you know any bail bondsmen in this area, let me know, because we might need them. But in any event, I always appreciate seeing people come in here, particularly this time of day with very little notice. Before we go, I want to give you a very quick Fani Willis update. Okay, I did it the other day, and I'll give you the abridged version of that update right now. I think the President Trump has now filed. So he's, I think, the last defendant in the Fulton County RICO case. He has now filed his notice of appeal. If I'm wrong, y'all will tell me, but I think I think today was the day, or maybe yes, I think it's been filed. So now all the defendants have filed their notice of appeal. So the case where they're seeking to have Fani Willis disqualified is squarely in the Georgia Court of Appeals. And the next thing that'll happen is the parties are going to start briefing the case. They're going to start filing legal pleadings that will be much more lengthy than the short pleading that we've gone over here today. But guess what? We can come here inside the law, and we can go through them together, and we can read them, and we can digest them, and we can analyze them and talk about them almost in real time. And I promise you, as soon as I get my hands on any of them, we'll come in here. I'll do a stream, even if it's short notice, and we'll talk about it. And we'll be able to see what the parties themselves are saying as to why Fani Willis needs to be disqualified from the case and the case dismissed because of her alleged malfeasance and misconduct, etc. We can also see what Fani Willis says in her responsive pleadings. She'll go after they'll file their pleadings. She'll file her briefings, and then we're going to see what we call amicus filings. You're going to have outsiders that want to inject their legal opinions. So you'll see lawyers filing what's called amicus curiae briefs, friends of the court briefs, alleging or asking the court to go one way or another. So we'll get to see some of that, I'm sure, as well. And in a couple of months, I'm guessing August, maybe July, but I'm thinking August, we're going to see the oral arguments take place, and it will be live streamed at the Court of Appeals, which is in downtown Atlanta. We can come here inside the law, and we can watch those together too. Bring your popcorn. That's going to be a good show. And then a few months after that, you're going to get the ruling from the Court of Appeals. And let's just say the ruling is to boot Fani from the case. Fani gets to appeal. She can ask the Georgia Supreme Court to put her back on the case, and vice versa. If the defendants lose and Fani is ordered that she's staying on the case, then they're called the appellants. That's the criminal. That's Trump and Roman. Those are the folks that are seeking her disqualification. They could appeal. So whoever loses at the Court of Appeals level can at least ask the Georgia Supreme Court to again to appeal the case. The Supreme Court doesn't have to take it. It's completely discretionary. But I think in a case like this, they might very well take it. There won't be a trial this year, not at all in this case. We've got a big election coming up next week. Judge McAfee will know at the end of next week if he's going to be a judge in Fulton County anymore. If he loses, he'll be a judge till the end of the year. If he doesn't lose, I got to show you this for those of you who missed it. If he loses, this is his challenger. Okay. Robert Patillo. And this is one of Robert Patillo's social media posts before he became a judicial candidate. This is a man who has very, very deep loathing for the criminal defendant, in this case, Donald Trump. And so if Judge McAfee loses, that guy takes over Judge McAfee's caseload, including the Trump RICO case. How long will you think it's going to take before one of the parties files a motion to have him recused from the case? And unlike New York, judges don't get to hear those things for themselves. In Georgia, another judge has to decide that. So I imagine Patillo would be gone, but that's just a guess. It's going to be very interesting. Next week is the judicial elections in Georgia. We'll know more then. We'll come back here inside the law. We'll talk about that. But we have a lot of things happening still in the Georgia RICO case, the Fannie Willis disqualification, things involving a lot of drama, still a lot of drama that's left to happen, unfortunately, in this case. But nevertheless, we will be here inside the law every single step of the way with you. And to be honest with you, I didn't start this channel simply to talk about Fannie Willis and Nathan Wade and Donald Trump and all these things. This happens to be the case that's one of the cases that's hot right now. But we're going to talk about other things. In Georgia, we've got the Lake and Riley case, the murder over in Athens, Georgia. Soon enough, we're going to have Hunter Biden's going to have a couple of trials getting underway this summer. We can talk about those. We can talk about when it kicks off. You've got the Idaho murders of the students out there. And just off the top of my head, those are some big name things. And so we can talk about all of those cases, and we can try to see what we can learn about the real justice system from in the context of looking at all those things. Again, please hit that like button, subscribe, tell your friends, your neighbors, anybody that will listen to you, ask them to please subscribe if they have any interest in this whatsoever. And we want to try to get to 30,000. Thank you for the super chats. If you want to support the channel, there are links provided in the descriptions to all the shows. And check out any other shows. Go back and look at them again to refresh yourself to some of these issues, because I do that when I want to figure out what we've talked about before, refresh my memory. I'll look at other videos that we've done, live or otherwise, because it's hard to keep all this in your head. But anyway, with that, I'm going to say good afternoon and thank you guys, all of you, for being here. And I will see you back here next time inside the